Grace and peace. I am live. I wish to make this video to exposit for you the ruling, as you may have heard from the Indiana Supreme Court, concerning SEA or SB1, the quote-unquote abortion ban that was passed during the special legislative session in 2022. Just a little bit of history. This is something that we have been very, very involved with. We had a rally the day after the overturning of Roe with about 600 Christians, people who want the equal protection of preborn children. Not necessarily that many people from pro-life groups, but born-again Christians just trying to love their neighbor as themselves. We had that rally to call Governor Holcomb to call that session. The session was called. It started in July. And so we were present. Representative John Jacob, Kurt Nicely, and others fought for just equal protection legislation. The vote on that was 93 no votes, 6 yes votes. That shows us where we're at, and we have a long way to go. But what was passed was a bill called SB1, and what that bill does is it vaguely claims to be an abortion ban, although it has many various exceptions. But what it does do specifically is it revokes licenses for abortion clinics, and it closes abortion clinics. And so I want to examine the Supreme Court's upholdment of this with you. I'm going to share my screen, and then I also want to share a couple other things. Today, we're released the final complete, so-called complete terminated pregnancy reports for 2022. And I was just writing some things down in the car with 2 phones comparing 2021 and 2022. There was a 294.62% increase in out-of-state abortions. And so when the Dobbs ruling came out and Ohio had their heartbeat trigger bill go into effect, the clinic in Indianapolis that I've ministered at the most, Women's Med Center, 1201 North Arlington, they have 2 other clinics in Ohio. Martin Haskell's the owner, one in Cincinnati, one in Dayton. And so when the heartbeat bill went into effect there, tons of cars were coming, tons of women were coming to kill their children in Indiana. And we saw that. And we see as soon as June into July and August, there's a huge spike in the numbers. And so that is accounted for just hundreds and hundreds and hundreds of children from other states destroyed. And truly, we did become an abortion tourist spot. Parkview North and Parkview Randalia here in Fort Wayne both performed abortions in 2022. I was born at Parkview North, so my brothers were born at Randalia. It just shows that there's a lot of issues going on. And so there's many notable things about this terminated pregnancy report, which I won't necessarily detail in this video. I have some friends that are working closely with the health department. Melanie from Hoosier Voices for Life. Grateful for the work she's doing. And we'll continue to share that work when it comes out, as we have collaborated on. Praise the Lord. Back to the decision. I'm going to attempt to share my screen. Let me find this decision here. All right, this is being shared. I have here the decision, and you should be able to see both of our. Okay, perfect. Let's do this. So I was present. I was there at the oral arguments. The only pro-lifers there, it was me, my friend, Melanie from Hoosier Voices for Life, and one other individual. I'm totally forgetting his name. I'm so sorry. From Hoosier Voices for Life. And Jody Smith was there. I believe Sue Swayze-Leibel was there. Tim Wesco and Liz Brown were the main pro-lifers there. I didn't really see any other reps. There were some Democratic reps, tons of news reporters. What's his face from the Indiana Family Council? I don't even think, maybe Micah Clark was there. I'm not even sure. It was not many people. I remember specifically they banned the color green in the oral arguments. Anyways, that was a good time. It's very cryptic and hard to tell what people are arguing for, because these justices are very specific. On the one side, when they're grilling Ken Falk from the ACLU, it sounds like they're totally pro-life and they're just going to throw away this injunction by this county. Kelsey Hanlon, this county judge. But when they argue against the Solicitor General, Fisher, it sounds like they're totally pro-abortion, right? And so they're kind of smart in that. But looking at, who dissented, who concurred with the opinion by Justice Moulter here, I think my predictions were pretty much came to pass. So it's Moulter, Rush, and Massa who are concurring with this opinion. Justice Slaughter concurs in the judgment with a separate opinion, and I read Justice Slaughter's opinion. It's not that long. It's very interesting, and I'll have to read it again. I think he might be onto something, and I'll get into that because there's some things that are really good about this decision, and there's some things that are pretty poor. And then Justice Goff, I remember he's sitting on the far right from me. Just absolute rubbish. I'm not even gonna honor or dignify his response among the learned men in the world, just because it's so terribly garbage. And it's similar to what we see people like our non-biologist friend in the U.S. Supreme Court doing, is just hogging all of the time and just repeating stupid liberal phrases over and over and over instead of actually, quoting case law or doing significant work that needs to be done in order to write a logical decision. So here's Moulter's. This is about 60 pages. I think this is about 40 pages, his decision. I read most of it so far. It's pretty good. There's some good things into it. I'm not going to read for you. That's going to take way too long. Let me scroll through and try to highlight a few things. So he gives some, recognize this is not from an abolitionist viewpoint. Okay, this is from a judge. And so there are many things that the language that I would like to be used is not used. However, that doesn't mean it's necessarily propositionally false. A lot of these things are phenomenological in nature insofar as they reflect sort of the current milieu of how things are referred to in the media and Associated Press and political correctness. And yet there still is substantive disagreement with the pro-abortion side, which we will see, and I'm very grateful for. So he talks here sort of, if you look at other state abortion decisions, they all sort of have this paragraph where they talk, well, it's a nuanced issue, it's a unique issue. They sort of all have this. This paragraph gives some history, which we've lived through. So hopefully you're at least somewhat familiar with that. He gets into the nature of what's called this facial challenge that was raised. I honestly think the ACLU was pretty dumb in how they raised this objection to the bill. Basically, if we can just find one part that isn't one part that isn't ended basically by the A clause in the Constitution, or in this case the privacy clause, they have no case. And so it was kind of dumb, but I think that this is right in regards to there's no reasonable likelihood of a success in their facial challenge. So just on that basis, they vacate the preliminary injunction. But he doesn't just stop there, which he could. History of Indiana's abortion law, this stuff, these are works I've read and stuff I've seen before. Actually, in the Dobbs decision, Justice, I believe it's Alito, quotes this 1835 law that our justice here quotes, which is very interesting. You have to understand a few things about abortion in the history of America. A lot of abortion you see in the history of early 19th century stuff is we recognize there really wasn't much DIY abortion because it was so dangerous and the technology wasn't available. So you do see outlawing of physician-performed abortion. In Ohio, for example, referred to it as child killing. But what is notable is that it wasn't just equal protection across the board, right? America has long been terrible on the issue of abortion, far before the Roe decision. While there are some states that had better than others, it's really quite sad. And that's a video for another day. So he gets into some of these laws. I've read this one here. These are helpful, and this is what I want to draw up for you here, is that the reason he's citing these is it shows that, and if we scroll down a little bit, it shows more that at the time that the Indiana Constitution and the clause that the ACLU is quoting to make their case for abortion, at the time that was written, the framers of that lived in a context in which abortion was already outlawed. So what that means in essence is there would have to be this huge contradiction between this big body of statutory law and what they're writing in the Constitution, but there's not. And so you're saying, in effect, that this part of the Indiana Constitution, this historic document, is fundamentally antithetical to the banning of abortion, and yet those two things coincided for literally hundreds of years. Well, okay, literally hundreds of years, 800, more than 100 years, right? Indiana is a young state. You go to somewhere like England, and you can live next to a church that has been around for 600 years. Anyways, not literally hundreds of years. That was an exaggeration. More than 100 years, more than a century. This is something that was brought up by Fisher in the oral arguments, and I think it was a good point. So that's really interesting. But it doesn't only have one purpose; it has a twofold purpose. What this also shows is that what it shows is that abortion is not a new issue. This was an argument given by Ken Falk from the ACLU, which is basically a response to the argument I just gave, which basically is to say, well, the framers of the Constitution weren't familiar with the issue of abortion, which could lead to the idea that we would have to really basically add new meanings or something new that falls under the equal protection or the privacy clause. Like, surely there will be some new technology, right? They didn't have phones, and yet the equal protection, or in this case, the privacy clause, can fall under the guise of something that happens on my phone. And so it is true that new technology can apply. What's the issue with that argument that the justice here shows and disproves? Abortion has been happening for millennia. Plato writes about abortion. All the early church fathers write about abortion. All of the common law sources way before the United States, way before Amerigo Vespucci and Columbus. Extremely familiar. You look at, we have this concept that no one knew what life was like in the womb beforehand, but you look at Leonardo da Vinci's sketches, and they're these beautifully, for the most part, anatomically correct drawings of prenatal humans. It's fantastic stuff. Anyways, that completely dispels that argument. And Fisher also brought this up. He said, no, abortion's been happening for millennia. Have you read The Republic? All that to say is, I think this is good, that this is drawn out. He goes into the history of how with the Roe decision, we have this trimester framework. And basically, within the, 3 trimesters, and breaking into which trimesters you can allow and which you can't. And it shows after the Casey decision in the early 90s, with a new sort of pseudo viability kind of undue burden standard, Indiana then conformed its laws to that. And what he's showing is a pattern of conformity to the U.S. Supreme Court. This is not a defy tyrant statement. I really wish you would have brought that up. I mean, for gosh sake, defy the stupid court. And there are other decisions by the same justice encouraging such, which I found. So I did a lot of research on these justices over these past months, really in anticipation and praying that justice would occur. So that's interesting. I'll leave that at that. Basically, saying under Roe, we did exactly what we were allowed to under Casey, Planned Parenthood versus Casey, 1992. We did what we were allowed to do, and now Dobbs, we're doing what we are allowed to do now. And so the Supreme Court's still God in the scenario, but at least this God isn't quite as bloodthirsty. It's not biblical justice, but in terms of accommodation, nomadic accommodation, right? Nomos law, and the curbing of evil through the use of the law as a curb. This is significant. I'm not saying this fits biblical justice. Don't mistake me. Nonetheless, this is substantive curbage, so to speak. This is a very important paragraph here. The United States has embraced the view of our predecessors in Cheney. The Cheney case is very interesting. One thing I'll say on this is he kind of basically is just dunking on the previous courts for 49 years of Thoreau, saying we were right about this all along in previous decisions here in Indiana. My predecessors, my justices, we knew all along, but now you guys are just catching up. So I thought that was kind of funny that there was just a little bit of godly use of snark, perhaps. Some procedural history. If you're interested why this says Hawaii and Alaska, for the longest time, Planned Parenthood in Indiana was Planned Parenthood Association, and it was combined with Indiana and Kentucky. And then they needed more funds, so they grouped in Indiana with the Great Northwest, like Washington, Oregon, and then Hawaii and Alaska. And their funds just skyrocketed, like tens of millions of dollars they had in extra funds, which explains how they got tens of thousands of people to their rallies in Indy. Amy Caldwell, yeah, she was pretty significant in this whole ordeal. This gets into Kelsey Hanlon's, the county judge's injunction. So there's a lot of interesting things here. All that to say is he basically finds that there is no right to abortion in the privacy clause, except for the life of the mother or the detrimental to the physical life. I'll find down here where it is. There's issues with that. I don't like that was added. I don't think it should be, and I'll read you the next decision, which is concurring, but with a couple different issues, which I think is right put, that they didn't need to take that up. They didn't need to define this life of the mother. I think that's pretty unfortunate. So through all of this, he's basically saying, we read the framers of the Constitution. We read sources on Lockean natural rights guarantees here. He talks about this for a while. And what this shows us is the privacy clause, the equal protection clause, like all of these things have a specific meaning at a specific time, and none of that whatsoever delimits giving protection to prenatal humans, which is something that is talked. The state interest in protecting human life is something that is mentioned, thankfully, in these decisions, actually multiple of them, which I'm grateful that we're even talking about that. So he talks about, like Lockean sort of theory as it relates to life, liberty, pursuit of happiness, and privacy and equal protection and all these things. To protect the weaker from injuries and insults of the stronger were societies first formed. When men entered into compacts to give up some of their natural rights, by that union and mutual assistance they must secure the rest. But they gave up no more than the nature of the thing required. Every society, all government, and every kind of civil compact, therefore, ought to be calculated for general good and safety of the community. George Mason, right, Lockean Natural Rights Guarantee. So I think that's very helpful. It shows us, what these things were originally drafted for. And when we try to understand really any text, we have to understand it in its context, in how it was written, which is something that any lawyer, Ken Falk, ACLU, just totally misunderstands. And so Article 1, Section 1, he goes through what it does guarantee. It says it guarantees certain fundamental rights. Bill of Indiana's Bill of Rights, life, liberty, pursuit of happiness, enumerated rights under the umbrella. So the question is, does abortion fall under one of these unenumerated rights under life, liberty, pursuit of happiness? And, they try to do the same thing with privacy. They try to do the same thing with equal protection. And his answer basically is, after studying all the sources, he just gives no. And I'm inclined to agree. Sort of the symmetry he talks about. I'm not going to be too long here. You can read it yourself, and I would encourage you to. So he argues that this, is judicially enforceable. There was this one interesting objection based upon changing language in the Constitution for pronouns, and my argument is that those are just stylistic changes. Those weren't feministic ones, although they may be. I'm not going to comment on the suffrage movement. He goes to the case law, which is very helpful. There are some very interesting cases I was looking at. What does this mean for us? I'm rambling a little bit. Let me summarize for you what this means. This basically means I spoke with a friend who spoke with a lawyer. This means, per Indiana appellate rules, the party has 30 days to file for a rehearing after a higher court issues an opinion. If they don't file for a rehearing, the order will go into effect. The Supreme Court would almost certainly not rehear the case unless they try to challenge the law on narrower grounds. So the religious freedom case, the Hoosier Jews case, its oral arguments are scheduled for September 12th at the Indiana Court of Appeals. Lord willing, I'll be there. We don't necessarily have to wait for that. We have to wait to see if the ACLU and these abortion clinic providers will refile after this opinion. I don't think they will. I'm not sure if they will. I pray they won't. Maybe the Lord would use it if they did, and then we get an even stronger opinion. Which I'm not going to go back here and talk about the opinion on the life of the mother. I might do a separate video on that just because I think it could have bad implications for us, and I pray it won't. But what does this mean? Likely, I would say August 1st, the ban will go back into effect. We were all thinking that it would go back into effect right away. Unfortunately, it doesn't look like it will, just based off what I'm hearing from these lawyers. There are some, I saw one lawyer, I think from IUPUI on Twitter, gave some really good analysis. So unfortunately, it's not going into effect right away. It doesn't look like. I'm going to try to keep us all updated, that we know what's going on. I will say there are major positives. There are major victories in this decision. If the Supreme Court would have just flat out recognized that there is an inchoate right, an unenumerated right to abortion under privacy, under life, or pursuit of happiness, if they would have just decided that and sort of mirrored the original Roe decision or even the Casey decision, of course I would fight to defy it just like we did for years under Roe. However, most pro-life leaders won't treat it like that. Unfortunately, I've talked with many who say, well, we just do exactly what we did for the last however many decades. And that would be a real shame. So Lord willing, we won't have to do that, at least not under this case, under this argument, under this court. In the future, it may come to that. It may come to that with the Court of Appeals. We don't know. We need to keep, remember to be the men of Issachar who had who understood the times. The scripture warns, St. Paul warns of the Jews and people who have zeal without knowledge as a very dangerous thing. So we need to continue to be very knowledgeable. I'm not a lawyer. I don't know much about this stuff. I try to. Praise the Lord that I've made connections where I can talk with a lawyer if I need to. I'm really grateful for the connections I have and the people, many people even at pro-life organizations, I'm exceedingly grateful for. So continue to be in prayer. I would encourage you to read the decision, at least skim through it. It's very interesting. Citations from the old laws are very significant. And again, the terminated pregnancy reports for 2022 came out, and they are devastating. 9,500 abortions in that year, and there's a lot of discrepancies, and I don't even think that's accurate, but at least 9,500 in 2022. You see this huge spike after the Dobbs decision, a 294.62% increase in out-of-state abortions. And that increase only happened for like the latter half of the year. And for part of the year, it was banned. The clinics were closed. That's terrible. It was devastating. And I didn't spend a crazy amount of the time at the clinics. I think I went down there probably 8 or 10, maybe 12 times in 2022. I looked on Google Maps and it tells me. I think I was there for 12 different days, maybe 14. Tells me Brian Schrank has been there much, much more, and he's seen this destruction. And all I can say is we need to weep and we need to mourn. And so perhaps we'll try to schedule some sort of day of mourning, maybe an event at the State House. We need to weep for all these children, friends. And if we can't weep over their deaths, we have no right to celebrate when there's a ruling in favor that may help them. And that's the truth. So anyways, please pray for our outreach. If you just now started watching the last 20 minutes, I've been giving updates on the history of SB1, SEA1, and going through a little bit of the court decision, just a little bit of it. Let me share my screen and I will. So this was the decision here. Very interesting. We're looking at about 60 pages in total. Let me go to this other, this concurrence, but there was a little bit of a dissent on the topic of the life of the mother here. Unfortunately, the original decision, which by the way, here are the amici curiae, Thomas More Society, theirs was pretty good. Some of these were pretty terrible. I remember in the Susan B. Anthony list, their friend of the court, amicus brief, amici curiae brief, basically argued, well, now more women are in politics. So there were less women in politics in 1973 and 1992. So praise God for strong lawyers that actually don't make terrible arguments. Slaughter's here is very interesting. Let me just try to summarize for you. Basically, there's a little bit of a dissent on if the court should have even touched on the health of the mother, the life of the mother. And I tend to agree that they shouldn't have even talked about it. I don't even think it was in the purview. And so why do I say that's not even in the purview of this decision and with this injunction? Simply because the ban already gave like way too broad of an exception. And so whatever you think the Constitution allows, by default, that was already allowed in the decision. So if there was any issue with that, just take it up if there's a different ban with a different injunction that on a bill that does not permit that, what you think to be an unenumerated right in Article 1, Section 1. So for these reasons, I concur in the court's judgment, but do not join in its opinion. I would encourage you all to read this. It's pretty short. It's helpful. Goff, again, interesting. It's basically the same regurgitated nonsense. Irreparable harm, pregnant women who seek to exercise the choice not to carry a pregnancy to term. So pretty sad. This gets into this. This was notable. This was a pretty terrible early on 1809 Indiana abortion law. A couple other things. So the state having a vested interest in the protection of human life is mentioned. Prenatal life. So let me just read this for you, and this will be my conclusion. At the same time, our laws have long reflected that Hoosiers, through their elected representatives, may collectively conclude that legal protections inherent in personhood commence before birth, so that the state's broad authority to protect the public health, wealth, and safety extends to protecting prenatal life. That's a great statement, and I think that'll be very useful, friends, going forward. Here's another thing. Okay, this is the most important. This is the crux right here. We hold that the providers, abortion providers, have standing to contest the constitutionality of Senate Bill 1 because the statute criminalizes their work. Yes, it does. And thus they face sort of imminent, direct personal injury. Injury is a legal term. They're not talking about physical injury. Our standing doctrine requires. They're saying the standing doctrine of the court requires that they can't perform their work, which is a great thing to hear. Then, after examining Article 1, Section 1's text, history, structure, and purpose, as well as our prior case law interpreting the provision, we hold that it is judicially enforceable. SB1 is enforceable by the court. Finally, we hold that Article 1, Section 1, this is the part of the Indiana Constitution that they quoted to make their case, the abortion providers did, protects a woman's right to an abortion that is necessary to protect her life or to protect her from a serious health risk. Terrible sentence, terrible statement, never should have been addressed, literally wasn't even relevant because the original law had that exception in the first place, and this other sort of concurrent, but not an agreement on the opinion, gets into that. So that's one thing I definitely take issue with. But then the rest here is good. But the General Assembly otherwise retains broad legislative discretion for determining whether and to the extent to which to prohibit abortions. Great statement. I pray that we would be consistent on that. So that's pretty much it. We'll see what the Court of Appeals does. We'll keep you updated. Thanks so much. I'm at 30 minutes. That's pretty much, I didn't want to go any longer. I really appreciate it. If anyone's watching, please pray tomorrow for Wayne. Big outreach, and I need a lot of prayer because I have a lot of decisions to make. So really appreciate it. Thank you so much.